Did you know that when India was formed, our framers, despite establishing a federal structure, explicitly rejected the American model of having separate federal and state courts? They insisted on a single, unified judicial hierarchy from the very top. Why was this? This unitary structure considered so absolutely crucial for the survival and consistency of India's democracy.
That decision, and you've hit on the key point right at the start, the establishment of the integrated judiciary is the absolute core concept of the Supreme Court. It fundamentally defines its power.
It's more than just a court.
It's far more than just the final court of appeal. It was designed from day one to be the ultimate, ever-vigilant sentinel of the Constitution and the fundamental guarantor of your rights.
Welcome back to the Deep Dive. Our mission today is a comprehensive, high-detail, UPSC-focused analysis of the Indian Supreme Court, drawing deeply and precisely from Chapter 26 of Laxmikanth's Indian Polity, 8th edition.
Right.
We are zeroing in on high-yield facts, crucial case laws, and the institutional dynamics you absolutely need to master this topic for both prelims and mains.
And this deep dive is, well, it's tailor-made for high-level preparation. We're trying to provide the clarity and the contextual linkages you need, especially connecting those foundational articles to modern previous year question themes.
You want to break it all down.
Yes, break down the complex, sometimes contentious architecture of Indian justice into manageable analytical segments.
And if this depth of content proves useful for your preparation, we humbly ask that you consider subscribing to the Simplified UPSC by PPP YouTube channel. If you are capable, please consider joining our paid membership. Your support is truly crucial for us to keep bringing this super useful, high-detail content to you without compromise.
And on that note, a huge shout out to all our existing members. Your dedicated support is absolutely invaluable and, well, it helps us immensely in creating these essential, time-consuming deep dive resources. Thank you for making this possible.
Please also take a moment to like this video and share your valuable comment below. That engagement truly makes a difference in helping us reach more dedicated aspirants.
And just a quick update on resources. We know you need practice, so free notes, including practice previous year questions, or PYQs relevant to today's discussion, are available immediately on our Telegram channel.
And for the Legend members?
And for our Legend YouTube members, premium notes with extra PYQs and comprehensive model mains answers are waiting for you on our Discord channel, so be sure to join there.
Okay, let's unpack this. Our deep dive today is structured around 4 major pillars. First, the integrated judiciary concept and the constitutional supremacy it enforces.
The foundation.
Exactly. Second, the highly debated judicial appointment system. We're going to focus intensely on the evolution, from consultation to the Collegium and that recent NJAC challenge.
A huge topic.
A huge one. Third, we will detail the court's vast jurisdiction, paying special attention to the critical writ powers. And finally, we tackle the dynamic, often controversial, cutting edge of judicial review and judicial activism.
All right, let's get into it.
Let's do it.
So let's begin with the concept that starts Chapter 26. India's unique integrated judicial system. You can find the details on page 414 of the text. To really appreciate the magnitude of this decision, we have to briefly look at the alternative.
The American alternative, a classic federal model.
Exactly. The U.S. Constitution establishes what's called a double system of courts. You have federal courts, which are generally confined to enforcing federal laws, and then you have separate state courts enforcing state laws.
So they operate in parallel.
They operate as parallel, independent hierarchies, and that reflects the robust sovereignty of the individual states in the American system.
But India consciously refused to replicate that model. Our framers, they opted for a single integrated hierarchy. Why? Why this strong preference for unity?
Well, this choice was very deliberate, and it was heavily debated in the Constituent Assembly. While India was defined as a union of states, reflecting a federal spirit, the framers prioritized national uniformity and consistency in the application of law above a strict federal separation. They feared, and I think rightly so, that having separate state judicial hierarchies...
It could lead to chaos.
It could lead to conflict, confusion, and ultimately undermine the national cohesion that was so fragile in the immediate post-independence era.
So the Supreme Court sits atop this single pyramid, where decisions flow down without any interruption.
Precisely. The Supreme Court is at the apex, then you have the high courts, and beneath those, the subordinate courts. Now, what is crucial for you as an aspirant is the implication of this.
Okay.
This single system enforces both central laws and state laws. This model, which was adopted structurally from the Government of India Act of 1935, is a significant piece of institutional evidence that reinforces the unitary bias within India's otherwise federal structure.
So it's a federal country, but with a unified court system.
That's a perfect way to put it. It ensures that throughout the entire territory, justice is administered under one singular system, guaranteeing consistency in fundamental law application.
That seamless enforcement structure is what gives the Supreme Court the authority to act as the ultimate defender of the Constitution. Let's transition now to its specific role as sentinel and defender.
Yes. The Supreme Court is explicitly assigned this heavy responsibility. The text refers to its role as the sentinel on the qui vive.
A French phrase.
A powerful French phrase, yes, meaning sentinel on the alert or on the watch. This term was famously cited by Chief Justice Kanya in the landmark case of A.K. Gopalan versus State of Madras back in 1950.
But just quoting the phrase doesn't really capture the full context for the learner. The Gopalan case itself is a perfect example of how the judiciary's role has evolved, isn't it? What was the central point of contention in 1950?
That is a critical linkage for UPSC, you're right. In A.K. Gopalan, 1950, the court was interpreting Article 21, which states that no person shall be deprived of life or personal liberty except according to procedure established by law.
Okay, procedure established by law.
The Supreme Court, in that early phase, adopted a very narrow, very restrictive view. It essentially said that if the legislature passed a law, any law, and established a procedure, even if that procedure seemed unfair or arbitrary, the court could not interfere.
So as long as there was a law, the court's hands were tied.
Pretty much. The court interpreted procedure established by law strictly in the British tradition, focusing solely on whether there was legislative sanction.
Meaning the court initially limited its own ability to judge the fairness or the reasonableness of the procedure itself.
Exactly. It was a very restrictive interpretation of the court's role as sentinel. However, the true evolution of the Supreme Court as the sentinel came much, much later in the landmark Maneka Gandhi versus Union of India case in 1978.
Maneka Gandhi, a huge turning point.
A massive one. This case effectively overturned the narrowness of Gopalan. The Supreme Court ruled that the procedure established by law must also be just, fair, and reasonable.
So it's not just about process, it's about justice.
Precisely. It imported the concept of substantive due process, which is common in the U.S. Constitution, into Article 21, dramatically expanding the court's power to scrutinize executive and legislative actions against the yardstick of inherent fairness.
Now that is the deep insight the learner needs. The evolution from just looking at legislative procedure to actually doing a judicial scrutiny of procedural fairness. This proactive defense of rights brings us directly to judicial review.
And judicial review, detailed on page 432, is the cornerstone of this defense. The Indian Constitution is supreme. That's the first principle. Therefore, any law enacted by the legislature must conform to the Constitution.
And if it doesn't?
That's where judicial review comes in. It's the power of the judiciary to examine the constitutionality of legislative enactments and executive orders.
Aspirants are often asked to compare the Indian model to the U.S. model regarding judicial review. What is the fundamental difference in its source?
The difference is really in the explicitness of the power. In the U.S., the power of judicial review is, well, it's implied. It was established not by the Constitution itself, but by the Supreme Court's landmark ruling in Marbury v. Madison in 1803.
So the court gave itself the power, in a way.
You could say that. In India, however, the power is explicitly provided for in the constitutional text, particularly in Article 13, which specifically declares that laws inconsistent with or in derogation of fundamental rights shall be void.
So to sum up this first part, we have a clear, integrated judicial structure.
Yes.
Enforcing a system where the Supreme Court has an explicit, constitutionally sanctioned power to review and potentially strike down legislation based on constitutional requirements.
Precisely. And this ensures that the supremacy of the Constitution is not merely theoretical, but is backed by a unified, vigilant judicial mechanism capable of uniform enforcement across every state and union territory. This anchors the entire democratic system.
A perfect foundation. Let's move on to segment 2, the politics of judicial appointments. The Supreme Court's independence, its ability to challenge the executive and a legislature, is wholly dependent on the process by which its judges are selected.
Indeed. The fundamental constitutional text states that judges of the Supreme Court are appointed by the president. This simple statement, however, launched decades of constitutional contention between the executive and the judiciary over the meaning of a single word.
Consultation.
Consultation, that's the one.
So let's detail the specifics on consultation, as required by the Constitution.
Okay. For the appointment of the Chief Justice of India, the CJI, the President consults with Supreme Court and High Court judges as he or she deems necessary. The process is slightly less rigid for the CJI.
But for the other judges?
However, for the appointment of other judges of the Supreme Court, the President must consult with the CJI and other relevant judges. The key point is that this consultation with the Chief Justice is obligatory for non-CJI appointments.
Why did the framers feel this mandatory consultation was necessary, even if it initially didn't require the executive to accept the advice?
It was intended as a crucial institutional safeguard. It curtails the absolute discretion of the executive branch, meaning the Prime Minister and the Cabinet.
So it's a check on political power.
It's a check. By mandating consultation with the most senior judicial officers, it ensures that appointments are informed by professional judicial assessment and are not solely based on political considerations or patronage or loyalty to the ruling party. It forces the executive to deliberate with the judiciary before formalizing the appointment.
And that sets the stage perfectly for one of the most critical battles in modern Indian polity, the Collegium versus NJAC controversy, which completely redefined that term, consultation. This is a guaranteed high-yield topic.
Oh, absolutely. This requires us to trace the judicial journey through the judges' cases. Initially, in the S.P. Gupta case of 1981, that's the first judge's case, the Supreme Court adopted the narrow view that consultation just meant seeking advice.
So the executive could ask, but didn't have to listen.
Exactly. The executive was not bound to accept the advice. This essentially gave the executive primacy in appointments.
But this executive primacy was pretty short-lived.
Very much so. The pendulum swung dramatically in the Supreme Court Advocates on Record Association versus Union of India case in 1993, the second judge's case.
This is the big one.
This is the big one. The Supreme Court overruled the 1981 judgment and fundamentally changed the constitutional interpretation. It ruled that consultation must effectively mean concurrence.
So not just talking, but agreeing.
Yes. And furthermore, it required the CJI to tender advice after consulting with two of his or her senior-most colleagues. This judicial interpretation legally established the Collegium system.
Which was then further refined 5 years later, correct?
Yes. In the 1998 third judge's case, which was a presidential reference, the SC clarified and expanded the Collegium. It ruled that the CJI must consult a collegium of 4 senior-most judges of the Supreme Court.
The CJI plus 4 model.
Exactly. The opinion of this CJI plus 4 collegium became binding on the president, provided the advice was unanimous. This structure cemented the practice where the judiciary essentially held primacy in judicial appointments.
So, by the late 1990s, the judiciary had successfully established control over its own membership. But this power dynamic naturally created friction, leading to the executive's massive attempt in 2014 to replace the Collegium.
That was the National Judicial Appointments Commission, or NJJC. The executive's argument was that the collegium system was opaque, it lacked accountability, and was, well, undemocratic.
The judges appointing judges critique.
That's the one. It was criticized as judges appointing judges. So they passed the 99th Constitutional Amendment Act and the associated National Judicial Appointments Commission Act in 2014.
And this would have created a commission with the law minister and 2 eminent persons.
Yes, the intention was to restore a balance or perhaps restore executive primacy. However, in the 2015 fourth judge's case, the Supreme Court delivered a stunning verdict, declaring both the 99th Amendment and the NJZ Act unconstitutional and void.
That decision ignited a huge public debate. What was the Supreme Court's core, non-negotiable argument for striking down a constitutional amendment that had been passed unanimously by Parliament?
The court's central argument was that the new system, by involving the executive in the appointment process, would fatally compromise the independence of the judiciary.
The basic structure doctrine.
Exactly. The court reiterated that judicial independence is a fundamental feature of the basic structure of the Constitution, which was established in Kesavananda Bharati. Since the NJAC structure violated this basic structure, it could not stand, and so the collegium system was restored.
That's fascinating political drama. But let's pause here because you mentioned that the Collegium system faces strong criticisms, which the UPSC aspirant has to acknowledge.
Absolutely.
While the court protected its institutional independence, critics argue the Collegium is opaque, it lacks transparency in its decision-making, and sometimes promotes dynastic appointments within the judiciary.
This tension is precisely why the debate persists. The sources clearly present the court's view that institutional independence is paramount, a shield against political interference.
But what about accountability?
Well, the subsequent debates following the restoration of the Collegium have centered on implementing greater internal transparency without sacrificing that independence. Proposals often revolve around standardized criteria for evaluation or making minutes of Collegium meetings public.
Which the SC generally resists.
Which they generally resist, yes.
Yeah.
Or creating a permanent secretariat to document judicial records. The core dilemma remains: how to maintain independence from the executive while achieving public accountability to the people.
That sets the context perfectly.
Yeah.
Moving to another protective power of the court, let's discuss contempt of court. This power seems necessary to maintain judicial dignity, especially in the face of political attacks following rulings like the NJAC verdict.
Absolutely. Contempt of court, detailed on page 419, is an essential power for safeguarding the institutional integrity of the judiciary. It ensures the proper administration of justice. Without the power to punish those who undermine its authority or interfere with proceedings, the rule of law itself would collapse.
What exactly constitutes contempt, and what are the penalties outlined in the sources?
Contempt is typically divided into two categories. You have civil contempt, which is willful disobedience of a court order, and criminal contempt.
Which is more about scandalizing the court.
Right. It includes scandalizing or lowering the authority of the court, prejudicing judicial proceedings, or interfering with the administration of justice. The punishment is serious: simple imprisonment for a term up to 6 months, or a fine up to 2,000 rupees, or both.
But the law has to carve out space for legitimate public discourse and scrutiny, especially in a democracy. Where does the source material draw the line between contempt and fair criticism?
This balance is vital. The Contempt of Court Act specifies some key exceptions. 1. Innocent publication and distribution of matter. 2. Fair and accurate reporting of judicial proceedings. And 3, most importantly, fair criticism of judicial acts. Criticism of a judgment, provided it is done in good faith and doesn't impute bad faith to the judge, is explicitly exempted. The court recognizes it has to tolerate robust critique.
And there's a crucial statutory time limit for initiating contempt proceedings.
Yes. The time limit is an important safeguard. No proceedings for contempt can be initiated after the expiry of 1 year from the date on which the contempt is alleged to have been committed.
And a little detail for aspirants.
A fine point detail, yes. The Contempt of Court Act is explicitly not applicable to contempt of Nyaya Panchayats or other village courts. Their jurisdiction and rules are derived differently.
So we've covered the fundamental structure and the contentious process of selecting and protecting the guardians of that structure. Let's shift now to what they actually do, their vast jurisdiction.
On to Segment 3.
Segment 3 takes us into the detailed map of the Supreme Court's authority. For serious preparation, knowing the specific constitutional articles defining each jurisdiction is non-negotiable, as detailed starting on page 433.
Absolutely. Let's start with original jurisdiction. This is the exclusive jurisdiction the court exercises when it hears disputes that cannot begin in any other court.
So federal disputes.
That falls under Article 131. This is the original jurisdiction, which specifically covers disputes between the union government and one or more states, or between 2 or more states, or between the union and some states on one side and other states on the other. It's the exclusive arena for disputes arising out of the federal structure.
Can you give us a sense of the kind of dispute that triggers Article 131?
Sure. Think about constitutional questions regarding the division of powers, or disputes over central policy implementation that affects state revenue, or legal challenges to the extent of state legislative power versus Parliament's power.
What's excluded?
Crucially, this jurisdiction does not extend to matters like interstate water disputes. Those have specific tribunals, or matters related to financial agreements made before the Constitution. It is purely focused on the federal legal relationship.
Okay. Moving to appeals. The appellate jurisdiction is what most people associate with the Supreme Court, but it's highly subdivided by the nature of the case.
Correct. The SC's role as the apex appellate body covers appeals from high courts across all categories.
Let's list them out.
Okay. Article 132 covers the appellate jurisdiction in constitutional cases. where the interpretation of the Constitution is required. Article 133 covers appellate jurisdiction in civil cases, generally requiring a substantial question of law.
And criminal cases.
Article 134 covers appellate jurisdiction in criminal cases. This includes cases where a high court has overturned an acquittal and sentenced someone to death, for instance. And finally, Article 134A deals with the administrative necessity of the certificate for appeal from the high courts.
Beyond these statutory appellate divisions, the SC also holds the vast power of special leave petition, SLP, under Article 136. This power gives the SC immense discretion, correct?
Oh, immense. Article 136 grants the Supreme Court the extraordinary discretion to grant special leave to appeal from any judgment, decree, determination, sentence, or order passed by any court or tribunal in the country.
Any court.
Any court or tribunal except military tribunals. This is the safety valve of the system. It allows the SC to intervene in cases where there might be a gross miscarriage of justice, even if the case doesn't fit the typical appellate categories. It transforms the SC from a mere court of appeal into a court of final judicial policy.
That leads us to the most critical jurisdiction for constitutional law, the writ jurisdiction. We have drilled down into the famous comparison between the Supreme Court under Article 32 and the High Court under Article 226. This is consistently tested.
It is. This comparison highlights the SC's unique constitutional obligation. We have to contrast the scope of power and the obligation to act.
Let's start with scope. Which court possesses the wider power to issue writs habeas corpus, mandamus, prohibition, certiorari, and quo warranto?
The High Court. Under Article 226, the High Court has the wider scope. The High Court can issue writs for the enforcement of fundamental rights and for any other purpose.
Any other purpose. That's the key phrase.
That's the one. It allows high courts to protect ordinary legal rights as well as fundamental ones. The Supreme Court, under Article 32, can issue writs only for the enforcement of fundamental rights. So in terms of the types of rights protected, the High Court is functionally wider.
That often surprises aspirants. But the critical difference lies in the obligation, which speaks volumes about the SC's constitutional mandate.
The difference in obligation is paramount. The remedy under Article 32 is itself a fundamental right. Therefore, the Supreme Court cannot refuse to exercise its writ jurisdiction if a fundamental right is demonstrably breached.
It has no choice.
It is constituted as the protector and guarantor of fundamental rights, and it must open its doors when these rights are threatened.
This is the element that B.R. Ambedkar famously referred to as the heart and soul of the Constitution. It guarantees that the constitutional promise is always enforceable at the highest level.
Precisely. Conversely, the remedy under Article 226 is discretionary. A high court may refuse to exercise its writ jurisdiction, for instance, if it feels the petitioner has adequate alternative legal remedies available.
So, wider scope for the High Court, but an absolute obligation for the Supreme Court.
A wider scope but discretionary power for the High Court. A narrower scope but an absolute obligation for the Supreme Court when fundamental rights are in question. This is a distinction you must internalize.
Moving beyond initial rulings, let's discuss the Supreme Court's power to shape the future of legal interpretation through the doctrine of prospective overruling.
Prospective overruling. It's a sophisticated tool of judicial policy that marries the necessity for legal evolution with the requirement of legal stability.
What does it mean in simple terms?
It means the Supreme Court can declare a new interpretation of the Constitution, or a law that will apply only to future cases and future transactions. It prevents the new ruling from invalidating all past actions or transactions that were based on the previous judicial interpretation.
So if the court overturns a legal understanding that has been in place for decades, the economic and social stability of the country isn't instantly shattered.
That is the exact rationale. I mean, think of the massive legal and economic fallout if rulings regarding land reform or taxation or core constitutional features like the basic structure doctrine itself were applied retroactively. The doctrine allows the court to introduce radical, necessary change without creating retroactive legal chaos.
And this doctrine is entirely a creation of judicial policy, correct? It's not explicitly written in the Constitution.
It is. It's a self-imposed limitation in power derived from the SC's authority to declare law binding on all courts. The source material emphasizes two key features. First, it can only be applied by the Supreme Court.
High courts can't do it.
High courts lack the authority to unilaterally declare prospective operation for their rulings. That would just undermine the entire legal hierarchy. And second, the scope of retroactive operation is left entirely to the SC's discretion. The court decides how far back, if at all, the new ruling might apply.
This ability to manage the impact of legal change is a testament to the institutional wisdom of the Supreme Court.
It certainly is.
Okay, let's move to our final segment.
Our final segment moves into the dynamic, living aspects of the Supreme Court's function. Judicial activism and its essential tool, public interest litigation, or PIL. This is where the judiciary transcends mere law application and proactively shapes social policy.
Right. So if judicial review is just checking laws against the Constitution, how does activism, detailed on page 437, differ?
Judicial review is an interpretation in light of constitutional parameters. Judicial activism is characterized by the deliberate expansion of judicial power and the molding of the law to suit the changing social and economic scenario. Its goal is to make the lofty ideals enshrined in the Constitution, like social and economic justice, meaningful and real for the common citizen.
So it's proactive.
It is about proactively doing justice rather than passively waiting for the appropriate legislative action.
It sounds like activism provides a procedure to evolve new principles.
It does. The source material refers to activism as the procedure used to evolve new concepts, maxims, and formula. For example, the expansion of the right to life under Article 21 to include the right to a clean environment, the right to health, or the right to a speedy trial.
Things that weren't explicitly written in 1950.
Exactly. They were found by the court to be necessary corollaries of the fundamental rights, often by entertaining litigation that affects entire sections of society.
This shift toward proactive justice was only truly possible because the court invented the mechanism of public interest litigation, or PIL, detailed on page 445. What structural barrier did PIL first have to overcome?
The traditional common law rule of locus standi.
Locus standi, right?
Right. This rule dictated that only a person whose rights were directly affected could approach the court for a remedy. So if a community was suffering from a factory polluting their water, only those individuals whose property or health was directly injured could file a case.
And PIL just shattered that.
Precisely. The Supreme Court relaxed the rigid rule of locus standi, facilitating the birth of PIL. Under this new regime, any public-spirited citizen, a journalist, or a social organization that has a sufficient interest can move the court on behalf of persons who are unable to approach the court themselves.
People who are poor or marginalized?
Yes, the poor, the ignorant, or those who are in a socially or economically disadvantaged position. It even led to what's known as epistolary jurisdiction, where a simple letter to the Chief Justice could be treated as a writ petition.
The intervention of PIL demonstrates the massive breadth of the court's modern impact. What are some of the most powerful real-world examples of PIL intervention cited in our sources?
Oh, the examples really show the court stepping in where the executive or legislature had failed. You see petitions coming directly from jails, prompting the SC to intervene against harassment and demanding speedy trials, effectively recognizing speedy trial as an aspect of Article 21.
Police accountability, too.
Yes. There are complaints against police atrocities, demanding investigation into deaths in custody, or the refusal to register cases.
The court's intervention has also been essential in environmental protection, even though that wasn't initially a fundamental right.
Absolutely. The court used PIL to intervene extensively in environmental governance, most famously in the MC Mehta cases. They forced the closure or relocation of polluting industries, mandated the use of CNG in public transport in Delhi, and strictly regulated mining.
And these aren't just legal interpretations. This is policymaking.
It is judicial policymaking, designed to enforce the fundamental right to life in a holistic sense. We also see interventions against atrocities on women, seeking justice in cases of bride-burning, rape, and kidnapping, showcasing the court's willingness to bypass traditional bureaucratic hurdles to ensure fundamental justice.
Given this expansive, policy-shaping role, the judiciary naturally faces the accusation of overreach. This brings us to the crucial fine line between activism and what the sources warn against, judicial adventurism.
And this internal self-critique by the courts is critical for the learner to understand the separation of powers. The Supreme Court has repeatedly cautioned that judicial activism must not devolve into judicial adventurism.
You can find that on page 443.
Yes, the court must operate within the system of historically validated restraints.
What are the practical dangers of crossing that line into adventurism?
Primarily interference with the functions of the executive and legislature. Courts have to recognize that administrative authorities have specialized expertise in administration. Things like budget planning, technical feasibility, logistics.
Things the judiciary inherently lacks.
Exactly. When the court starts setting deadlines for policy implementation or detailing specific administrative procedures, it risks making unworkable orders and violating the principle of the separation of powers.
And the judiciary, by intervening, also opens itself up to the same criticism it levies against the other branches of government.
That is a powerful point of judicial self-restraint noted in the sources. The justification for judicial intervention is often that the executive or legislature are not doing their jobs. However, the courts must look inward and acknowledge their own shortcomings.
Like cases pending for decades.
Exactly, cases pending for half a century. If the courts are inefficient in their primary duty of speedy justice, they risk losing the moral high ground required for engaging in policy activism. This highlights a systemic need for judicial efficiency and self-restraint alongside activism.
So the synthesis is clear. The SC has to constantly balance its essential role as the constitutional sentinel, through judicial review and PIL, with the necessity of institutional respect for the separation of powers, exercising self-restraint when dealing with purely policy and administrative matters.
That's the tightrope they walk.
So to wrap up,
today, we conducted an exhaustive deep dive into the Supreme Court. We detailed its integrated structure, traced the contentious evolution of judicial appointments from consultation to concurrence, and mapped its comprehensive jurisdiction across original, appellate, and writ powers.
And we didn't stop there.
No. We also thoroughly explored its evolving role through the powerful, policy-shaping lens of judicial activism and PIL, focusing on the high-yield facts and foundational case laws required for your preparation.
This robust exploration of Chapter 26 really highlights how pivotal the Supreme Court is, not just as a legal body ensuring conformity to laws, but as a proactive socio-political institution that continually shapes and molds the Constitution to fit modern social and economic realities.
And mastering the interplay between institutional independence, judicial activism, and the requirement for self-restraint is crucial for analyzing modern Indian governance. This deep dive should provide the detailed structural knowledge you need to tackle complex analytical questions about the judiciary in both your prelims and mains papers.
And if you found immense value here, and this deep dive was useful for your UPSC preparation, please subscribe to the Simplified UPSC by PPP YouTube channel. We humbly request you to like this video and share your comments below. Your engagement genuinely fuels our ability to continue producing these resources.
And don't forget, you can access free notes and practice PYQs by joining our Telegram channel. If you are a Legend YouTube member, premium notes with extra PYQs and detailed model mains answers are available exclusively on our Discord channel. Your continued support allows us to keep producing these essential, high-detail deep dives.
As we close this deep dive, let's leave you with one final provocative thought for your continued study.
Given the Supreme Court's robust role as the guarantor of fundamental rights and its expansive power of judicial review and activism, consider this, how effectively can a written constitution remain truly rigid when faced with the constant immense social and economic pressures of a billion-person democracy? Is the Indian Constitution ultimately a fixed document, or is it a dynamic, living mandate continually being rewritten by judicial interpretation to meet the changing needs of the Republic? Something profound to mull over as you continue your journey of preparation.